Especially timely and urgent, as Door County now has 13 impaired waterways. That's up from 10 last year. The dead zone in the Green Bay continues to grow. These challenges remind us while our efforts may seem small, together we can accomplish great things. Your membership and support are vital investments for our future generations who cherish Door County, as we do today. This evening is part of our ongoing effort to foster preservation through agency, education, and action. Our work this year includes continuing our speaker series, like tonight, supporting education and action, and critical phosphorus and beach water testing, awarding scholarships to students passionate about the environment and advocating for the protection of our natural resources at every level. We also want to take a moment to express our heartfelt gratitude to the Door County Community Foundation for their generous grant, which helps us make tonight's program and many of our other ongoing initiatives possible. The support strengthens our ability to educate, advocate, and inspire action within the community. Tonight's program reflects this mission perfectly. The Door County Environmental Council is proud to present Healthy Lands, Healthy Water, Legal Pathways to a Just Wisconsin with Adam Voskuil, the staff attorney at the Midwest Environmental Advocates, MEA. Attorney Voskuil has shared his insights on recent and pending lawsuits that could continue to shape the environmental law and protections in Wisconsin. Adam brings a wealth of expertise to this discussion. He graduated from the University of Wisconsin-Madison with degrees in conservation, biology, and sociology, certificates in environmental studies, integrated studies of science, engineering, and society. He went on to earn his law degree with the University of Minnesota Twin Cities, focusing on the environmental and energy law. At MEA, he concentrates on the agricultural law and policy issues across Wisconsin. Midwest Environmental Advocates is a nonprofit environmental law center that fights for the policies in protecting our natural resources and the health of Wisconsin's families. By offering a client-centered legal services, they empower the individuals and grassroots groups to hold industry and government accountable to the environmental and public health standards. Please join me in welcoming Adam Voskuil.
We're back. How are we doing tonight? Good. Great. Thank you first and foremost to DCEC for bringing me in and bringing a couple of my colleagues in. We get to enjoy Door County. Last I heard it was raining in Madison, so I'll take the sunshine here. I think the first two slides have almost already been taken care of, but we'll go through them anyway. When Mike first reached out to me to speak with you all, the kind of starting prompt was, could you share a bit about what MEA is doing and some of the work that's ongoing and maybe looking into the future? And I took that and ran with it, but I also went backwards a bit too, because I think really to understand why we're here, it's really important to understand where we've been for a bit for environmental law. And then that sets us up to talk about the opportunities going forward. So I'll talk as this goes on about a few themes that I have running through the presentation tonight. But just wanted to caveat at the beginning, we're going backwards, then present, and then forward. So a quick span of like a decade and a half. All right. Oh, that's why. I step away from. There we go. All right. And I guess I should double check because I think I'm the host. Are you able to see if anyone chats, Mike? And do we need to start the recording?
Yes.
Okay.
We have 13 people online.
Fantastic. All right. So to begin, just a little bit of a refresher from about a minute ago of what MEA is. Midwest Environmental Advocates was started at this point, I think 26 years ago, after an organization or a department within the Department of Justice. The public intervener was abolished by the governor. And we are the only nonprofit environmental law center that directly represents community members and organizations across the state in litigation. As it says, we work to secure and protect the rights of all people to healthy water, land, and air. One of the things that I love about MEA and the thing that really drew me to this organization is if you look at a lawsuit that we're working on, the title is not Midwest Environmental Advocates v. DNR. Instead, it is the folks that are actually impacted by the decisions that have been made or the pollution that's plaguing their household. I think that's something really special, and it really goes to show the longevity of both our organization and the fact that we're powered by the people across the state. So MEA does not take any government grants. We operate through donations and funds from the public, and that gives us that autonomy to sue the DNR occasionally, in addition to the polluters across the state. I find that really special. I got like 3 lawsuits going, and the DNR is named in all of them. So, all right. And we heard a little bit about myself, but I'll just introduce. Oh, one of these days we'll figure out technology. All right, I'll introduce myself a bit more. I have been at MEA for about 5 years. I was born and raised in Wisconsin. But even before that, when I was a law student at University of Minnesota, I was a volunteer at MEA. I worked on a number of projects. So I actually have ties to this organization for about a decade at this point, which is just a really interesting thing. I've seen kind of the start and in some instances, the completion of very long-term projects. The projects that we work on aren't done in a matter of weeks or months. They often take years. Litigation is a time-consuming process. There's a case where we started in 2011, 2012. I'll talk about it later, the Kinnard Farms case. Some of you may know it. That case was decided by the Supreme Court in 2021, which is, it would have been, after the fact, it'd be nice to say that it took a full decade, but I think we're all happy that it came a bit shorter than that. I work on industrial agriculture, concentrated animal feeding operations, and my work has spanned, as this says, all corners of the state. I've worked, by Milwaukee. I've worked in Southwest Wisconsin, up in Bayfield, and then in Kewaunee County, Door County, Brown, Manitowoc, Portage County. So basically everywhere. There are groundwater contamination issues, nitrate issues, but I focus on a somewhat niche area, and the topics of discussion tonight are going to expand beyond that. So there's a caveat later on, but if anyone has questions, I'll try my best to answer. But to the extent they're on some of the myriad of cases that span outside of my area of expertise, I'm happy to have conversations after or connect with you further. Run a show. I always like doing these because it kind of lets people figure out how we're going to proceed throughout the night. And we're going to start with the caveats. I already gave one. I have a singular focus or a very niche focus, but I would love to talk with you more about some of the other topics that MEA is working on, right? We've got litigation that came in front of the Supreme Court related to the spills law. We're working on energy issues. We're working on PFAS and other contaminants. I have colleagues here that may be able to help me. I also have colleagues back in Madison. Does this sound weird? I have cards that I'd be happy to give out, and to the extent we want any follow-up conversations on topics outside of my general area of expertise, let's chat further. I am always available for a phone call or an email. The other caveat that I'll give is this is super legal stuff, and I tried to make it interesting, but it's occasionally not, and sometimes it's pretty confusing. So to the extent I start going down a path that doesn't make sense, anyone feel free to shout out. Anyone feel free to raise your hand and ask another question. There's time at the end for questions, but if you don't know what I'm talking about, there's a pretty good chance that the rest of the room also doesn't know what I'm talking about. And so I think I would appreciate it, and everyone else would, if someone just said, like, stop talking and go back. Fill us in. But after that, after the caveats, I'll give you what will be 3 years of environmental law school in 3 slides. So you should be ready to litigate your next case. After that, we'll look a bit backwards. and we'll talk about some of the cases that happened in the last 5 years. And then we'll talk about some of the cases that we have pending, some of the cases that me and my colleagues have had the opportunity to argue, and we're just waiting on the Court of Appeals or the Supreme Court to weigh in. And then we'll talk about some of those recent decisions that were just discussed and where we can go from there. And I want folks to think about two really important things as we talk about all of these cases tonight. One is the power that the DNR currently has. I think there's a lot of discussion, and the power of the state in general. I think there's been a lot of discussion. We've all heard the news over the last 6-8 months about at the federal level, but that's not diminishing the power of the state in a lot of instances. The DNR and Wisconsin have a lot of ability to protect communities across the state and preserve natural resources. And so a lot of the cases that I'm talking about are state law cases, and they are in some instances ways that the DNR's authority has been affirmed to protect Wisconsinites. And in other instances, it's been our work to prevent rollbacks. And all of those decisions are unbelievably important, particularly when some of those backstops that may exist at the federal level don't exist anymore. And then the other thing I want folks to think about is the power of public advocacy. The DNR is responsive to people submitting comments, people telling them what they're doing wrong. They're only going to be able to change a permit or fix a rule if they know that it's a problem. And so some of the cases that I'm going to talk about tonight are instances where we told the DNR they screwed up, and if they didn't do what we wanted, we litigated on the back end. But the only way that we can start doing that is by making our voice heard. And so those are the two things that I just want to have everyone thinking about as we're talking tonight. All right. Year one of law school. So I have to actually read this one to make sure I follow it through. So I think an important thing to think about for environmental laws in Wisconsin are that they may start with bedrock federal laws, right? We know of the Clean Water Act, we know of the Clean Air Act. How does that function in Wisconsin? And in a lot of those instances, Wisconsin has their own version. Sometimes that's a delegated authority program. So for example, the Clean Water Act says polluters have to get a permit. If you're gonna have a pipe that shoots contaminants into a stream, you have to have a permit from the EPA. But there's this provision that allows states to take over that authority. And Wisconsin was delegated that authority in the 70s. And so when we're thinking of things like the Clean Water Act, it's important to note that if we see rollbacks with, you may have heard of Waters of the United States or WOTUS, Wisconsin has its own definition of those waters. And so there's just a different, it's different, right? So year one of environmental law is just knowing that federal laws exist, but tonight we're going to talk about the state laws because they end up affecting us, affecting a lot of Wisconsin communities much more, at least in the environmental realm. Here's an example. So like I said, I work on CAFOs, which means I already had this little graph already prepared from a different presentation. But in this instance, we have the Federal Clean Water Act. The Federal Clean Water Act says states can take over for us. Wisconsin has decided to do so. But that just says when that occurred, the legislature just said, hey, DNR, do this. And the result of that is that the DNR then has to promulgate rules, the actual specifics of what everyone has to comply with. So when we're talking about CAFOs, which are industrial farms, does everyone here know what CAFOs are? I'm happy to explain them. Okay, I'm seeing a lot of nodding heads. That means that they have to comply with these very specific rules. So we're getting more specific as we get further down. You know, we've got federal, pretty broad, state legislature, a little bit more specific, DNR rules, very specific. And so a lot of my work and a lot of MEA's work tends to be along the administrative rules and the statutes at the state level.
CAFO, is that an acronym?
Yeah, sorry.
It's Alcatraz for cow.
What was that?
Alcatraz for cow.
That's I'm gonna use that. CAFOs, it's an acronym, it's Concentrated Animal Feeding Operations. It tends to be places with at least 1,000 cows. It can go upwards of 10, 12,000. They're kept inside, and all of their waste is aggregated and held in lagoons before it's then spread untreated on fields. They're defined in, you've got me in my niche. I could talk about CAFOs for hours. But they are defined as point sources in both the Clean Water Act and state law because the way they operate tends to directly discharge to groundwater and surface water. So because of that, they're treated akin to factories or other kind of the typical corporations that discharge into waters. All right, last thing before I believe before we go into some specifics of what MEA has been working on. This is just like a general timeline and a way to think about environmental laws and environmental regulation in Wisconsin. So the legislature passes a law, right? And it says something like what I have quoted here, which is just the department shall promulgate rules setting standards for water quality. That doesn't give a lot of information, right? It directs the DNR to do something, but it doesn't set any of those numbers. So DNR has to then interpret what that means and then actually pass what those standards are, what the specific numerical standards may be, what the criteria are, if it is fishable or swimmable. That falls on a department, an agency to figure that out. They then write a rule and they circulate it to the public and they ask, what do you think about it? And so industry members can submit comments, the general public can submit comments. Over time, they'll aggregate all of those comments and then they'll consider them. They may revise the rule, they may not, but they will eventually issue a final rule and send it to the legislature for subsequent review before it is ultimately sent to the governor, approved and published. So all that to say, we go from a relatively narrow directive from the legislature to very specific rules that folks have to deal with, and the public gets an opportunity to weigh in on what those rules can look like. And then on the back end, once the rules exist, I get to litigate them, which is my favorite part. Which gets us kind of to our takeaways. Administrative agencies hold a whole bunch of power, right? I just said the DNR makes that language, the public gets to comment on it, that language becomes law. Agency decision-making can take many forms. That can be rulemaking like we've talked about, but you'll see as we go forward that we take that language that the agencies create and then we ask for it to be included in permits to specific polluters across the state. And in all of those instances, it's public advocacy and, kind of being firm and maybe threatening litigation every once in a while that convinces the department to include more strong environmental protections. And then the last thing, as I just said, the public it plays a huge role. If it were just me commenting on permits, I'm not sure that the DNR at some point would stop taking my calls. They'd be like, who is this crazy guy? And how did he get our number? But if we've got a critical mass of folks saying, I can't drink my water, or I'm seeing something on the ground and you're not doing anything about it, that's the thing that really convinces DNR to take action. And I'm not everywhere. And so MEA a lot of times leans on the folks in communities to be our eyes, our ears, and then we work to lift up their voices. All right. Let's talk about some wins, huh? Start with the easy one. This is a case that was started in, like I said, 2012, I want to say. And it was related to the expansion of a specific CAFO in Kewaunee County. I can't remember the exact numbers, but they were intending to open up a second site. and there were concerns of how this CAFO was operating, particularly whether or not they were actually keeping track of how much waste they had. And then in managing their waste and spreading on fields, there were folks across Kewaunee County that were having brown water events, right? People were turning on their taps and just seeing brown water come out. There are pictures of bathtubs, there are mason jar pictures. It made national news. And there was a push for better, more protective permit terms, right? If this CAFO is going to operate, what assurances do we have that it's not going to immediately contaminate all of the water in the county? And in 2014, an administrative law judge, following a contested case hearing, called DNR's CAFO program in Kewaunee County a massive regulatory failure. And that kicked off 7 more years of figuring out what that meant. That judge said that DNR in the permit that was issued to the CAFO had to include an animal unit limit, the max size that the CAFO could get to, Kindred Farms, and then they also needed to include monitoring on land spreading fields, saying if you're gonna spread this waste in a highly susceptible area, we gotta figure out where it's going. We have to figure out how much of it is getting off the fields, and then we're gonna do something about it when that happens. And around 2015, 2016, the CAFO pushed back and said, actually, DNR, you don't have the authority to tell us that. And they went to some statutes and they said, all you can say is verbatim what's in the statute, which said very little on groundwater monitoring, but it did have a provision that said DNR could include any permit term necessary to assure compliance with groundwater quality standards. And so for 6 years, we had to argue what that one sentence meant. Eventually, it got to the state Supreme Court, and in July 8th of 2021, the Supreme Court affirmed DNR's authority. They said, it seems pretty clear to us. If DNR has to issue permits that include terms, then those terms can't include groundwater monitoring. And so you would think then that everything was resolved and every CAFO has groundwater monitoring. No, it's a slow slog, but we're continuing to push. And at least these days, we're not arguing about whether DNR can do this stuff, right? That's kind of the slow bend. And now we've got 5 CAFOs out of the 335 in the state that have groundwater monitoring term provisions, and we're pushing with each one that gets added. But the starting point was this, because if a court says suddenly the Department of Natural Resources can't do this, the permits effectively become meaningless. We have no ability to ask for more protective terms. And so now when folks call MEA and they ask about what can I do, there's, our water doesn't seem to be drinkable, or there's a CAFO that's looking to expand. One of the starting points is, well, what terms can we ask for? Because the Supreme Court has at least affirmed that much. All right. Uh-oh. I promise it's not me. All right. Meteor timber, we're off CAFOs for a second, so I'm a little outside my depth. I'll talk through it. So meteor timber was about a here, this is my safe space. Meteor timber was about a DNR permit to fill a wetland. And MEA represented the Ho-Chunk Nation in that case. Like I said, we're not representing ourselves when we bring the majority of our litigation. We are representing groups, community members, tribal nations in some instances. And I actually still cite this case in a brief that I filed or a memo that I drafted last week. I cited this case. One of the things that occurred in this was after public scrutiny and public outcry about the inadequacy of a permit, the DNR attempted to backfill the record during the contested case hearing. When everyone was challenging this thing, They were like, actually, look at all this other stuff that supports our findings. They're just throwing everything at the wall and seeing what sticks. And the Court of Appeals rejected that in 2022. And so this just goes to show, you know, being proactive, reaching out and like I said, telling the DNR when they're doing something wrong. It has value, even if ultimately they make a decision that you disagree with. If I get to litigate it later, it tends to, well, I didn't litigate this one, someone else did, but it tends to work out. One more past case, and then we'll talk about some more recent successes. Lake Superior bottling. We're talking about a lake, that's kind of blue. So I worked with one of my colleagues. We were working on an issue up around Bayfield County, where a landowner wanted to start withdrawing water from Lake Superior and bottling it and selling it. They would be their own small, tiny, like Evian or Dasani bottling company. Pretty problematic. You're not supposed to take water from the Great Lakes and just start selling it nationwide. But it's a pristine water body, and so there was a lot of incentive to do so. The county denied that permit, the conditional use permit. So we're no longer talking about the Department of Natural Resources. This is highlighting some of the work that MEA has done at the local level. We represented a community group called Lake Superior Not for Sale, and supported the county's decision. I argued in front of their Board of Adjustment, and then we filed a brief in front of the Court of Appeals reaffirming that this thing shouldn't exist. It has no business existing, and the county made the right decision in saying, no, you can't take all of our water. And the Court of Appeals last December affirmed that decision, which is again a huge win. The folks up there were incredibly appreciative, but I will say that was again like a 4-year battle. These things, like I said, don't come in days, they don't come in months. It's an iterative process. All right. Again, we're back to CAFO, so I'm in my home base. WDA v. DNR. This is a case that if Kennard Farms was the case that allowed us to maybe push the envelope and think about what DNR could do related to CAFO permits, this case is the one that says, maybe DNR can't do anything. At least that's what industry is arguing. They brought a challenge to DNR's requirement that CAFOs simply apply for a permit in order to operate. There are other states that have adopted this. I believe Indiana is one, Ohio is one. In Ohio, out of the, can't remember the numbers exactly, but around the 237, I believe, large CAFOs that exist in that state. As a result of the rule that's being pushed here, 0 of them have permits. So they're just operating without DNR or their version of DNR's regulatory oversight. So like I said, if there are instances where litigation has an opportunity to push and ask for more, there are also instances where MEA's work is crucial to prevent backsliding, if that's what you want to call this. This would be a reversion past what I could envision, but I guess it'd be some version of backsliding. And so we represent the Wisconsin Farmers Union, and we intervened in that case in 2022 when at that time a Calumet County judge, and did I put the year? 2024, January 30th, rejected industry's argument, but they almost immediately appealed. And so now we're waiting this decision out at the Court of Appeals. There's no telling when exactly the Court of Appeals will rule on this. One of the weird quirks of Wisconsin's Court of Appeals is they have this ability to just sit on decisions for, forever. And so I'm hopeful that we get a decision rejecting industry's argument sometime in the next, we'll say 6 to 18 months. But we'll be ready to fight it if there's an adverse decision up to the Supreme Court, because the result, a result where no CAFO in the state has a permit means, there's no groundwater monitoring, but there's also no requirements that manure lagoons meet engineering standards, or that spreading on fields are done in ways that don't immediately flow off into someone's, well or field. So
But industrialized, where, an NPDS permit, rather than Wisconsin permit, wouldn't that be much a stronger permit for them to force them to better take care of whatever they're doing?
that's a good question. So for maybe anyone online and anyone that didn't hear, there was a question about the distinction of the WPDES permit, the Wisconsin Pollutant Discharge Elimination Permit, and a question of why CAFOs or other industrial farms aren't applying for the NPDES, the National Pollutant Discharge Elimination System permit. So that would be the one that's overseen by the EPA. The primary reason would be that the entire kind of permitting process was delegated to Wisconsin in the 70s. But I would say maybe that's just that every discharger gets a WIPDES permit rather than a NIPDES permit in our state. But the other thing that's important to consider on that question is that Wisconsin defines waters of the state to include groundwater, which means that every WPDES permit has to include provisions that protect groundwater in a way that every NPDES permit doesn't. So if we remember, there were some fights over waters of the United States between the Biden administration and the Trump administration, and a question of what is considered a water of the United States. For simplest purposes, it's typically navigable waters, and groundwater almost never at the federal level is included in a water of the United States, which means an NPDES permit couldn't have protections to groundwater in the same way. I will note that the cases that are being cited by industry in this lawsuit are explicitly pulling from states that don't include groundwater in their protections, which is why they argue that their argument is that, look, in these states, their DNR doesn't get to regulate large CAFOs. So that should apply here in Wisconsin as well. And everyone's response to that, well, the reasonable people's response to that is Wisconsin regulates more. We have a long history of environmental ethics, and as a result, have drafted some pretty powerful and pretty strong laws that protect the environment, like the definition of waters of the state that includes groundwater in a way that the federal government doesn't protect. And as a result, we can do things like, say, groundwater monitoring has to occur on fields, and that could not happen at the federal level. Yeah.
I just want to say, our foundation went to the Hill in April of this year and talked to our representatives, and I just had one sentence about, or paragraph about cables, and basically it was, cables should not be permitted in any county in Wisconsin that has soft bedrock, such as hers, because what's happened with the Kewanee canard, 12,000 cow poops a day. They've been spewing in Kewanee, Brown, and Southern Door. All of those farms now have E. coli in their wells, and it's very expensive to get, to have clear it out, and it only clears it out 80%. And I mean, when did humans have some rights here?
Right.
I guess, but I want to ask.
Yeah. So a couple of things about that. Like I said, one of the things to think about has been the value of rulemaking when it,
Yes.
through the DNR. In 2019, the DNR attempted to pass more strict spreading restrictions. It wouldn't be so far as no CAFOs, but it was what they called it at the time a targeted nitrate standard that would have had some pretty impressive restrictions on spreading liquid manure across the state. That ended up getting held up in, we'll call it legislative rigmarole.
In the western states, you have, I guess, it isn't cursed, and so they just complain about the smell.
Well,
but we have a problem with aquifer and wells.
so in the western part of the state, it's still it's Silurian dolomite, but a different type of geology. but it's overlain by a significant amount of clay. So their concern is twofold. One, because I'm getting very technical and I apologize. Because it's unglaciated over there, you have low parts where suddenly there is some pretty thin depth to bedrock, but you have on the tops of hills some pretty, it's pretty thick before you get to the softer bedrock. But their concern is because that clay type like soil is an impervious surface, it has the ability to flow down and amass in the basins. And then if you want, like I said, I do CAFO work across the state, so I'll talk about this all night. If you get to the central part of the state, then you're out of karst, right? Then you're out of Silurian dolomite, you're out of the overlaying clay regions in the western part of the state. But there you have porous, like sandy soils. It's the central sands region. And so there's a world in which the next slide, I think we're like 3 slides away, is one of the cases that I'm litigating in the central sands portion, which is a CAFO where a disproportionate number of folks just south or down gradient of the only CAFO in Portage County have pretty substantial nitrate contamination. And they're like, do something about that guy. And DNR said no. And now DNR is saying, well, maybe we'll try. So we're fighting that fight there, but all that to say, across the state, right? It's certainly in Door and Kewaunee County where you have like in some instances less than 12 inches depth to bedrock and the karstic Silurian dolomite like fractured carbonate features. I would agree with you, but I think it's also important to note like the CAFOs in spreading, particularly in the highly susceptible areas across the state, are a problem. And so DNR tried to do something in 2019. They were held up by the legislature. But I'm hopeful that some of the decisions that just came out in the last 8 days may set up a future fight related to improved rulemaking and more protections as it relates to CAFO spreading. Yeah.
Who was the industry group that made that challenge?
The industry group that made the challenge was Wisconsin Dairy Alliance and then Venture Dairy Cooperative. And they may be, I want to say they're also represented by Wisconsin Manufacturers and Commerce's Litigation Center.
And if somebody asks a question, you might just summarize.
Oh, yeah, sorry.
I'm not so sure that,
Yeah, I apologize to everyone online.
I think they may be hearing, but I just wanted to remind you, we have another microphone I can.
Yeah. All right. I think I've got one more. All right, so the WDA case, I've started to get into the ramifications of that case, which could be CAFOs don't have permits in the state anymore, which would be a huge problem. And it's pending at the Court of Appeals with, I put a decision, hopefully likely 2026, early 2026. As I said, if they go 18 months, we're looking at 2027. But let's all be hopeful. Let's cross our fingers we get a decision before then. And I will note actually this final point. Last August, MEA representing Wisconsin Farmers Union co-filed a motion to bypass the Court of Appeals and asked the Supreme Court to take this up instead, because we were concerned about how long this case could linger at the Court of Appeals. We figured that this case, brought a number of concerns and had the ability to fully upheave the regulatory structure of CAFOs in the state. And so we thought maybe the Supreme Court would want to take it up. They opted not to, but I believe that it was because they realized that the law is so clear, right? That I truly don't believe that there's much that the opposing parties are able to stand on in bringing this lawsuit. And so I think that the reason that the Supreme Court passed on this is if it got to them, it would be a pretty wild decision from the Court of Appeals. And so they believe that it can be handled by that court.
What makes the Court of Appeals so long? Are they overworked, too many cases?
Yeah.
Dragging their feet, they have to study it.
Yeah. So for the folks online, the question was what's taking the Court of Appeals so long to decide some of these cases. I think it's a lot of different factors. I can tell you that there were 4 district courts of appeals. I track District 1, which is the Milwaukee district, pretty frequently, because I have some other cases that are in front of them. I believe they have something, last I checked, of like 675 pending cases, and that's getting added to all the time. They issue about 3 decisions a week. And so in that instances, it's just slow. The time also increases depending on how difficult the case is or how complex the case is. And you know, the last thing, there may be, I loathe to attribute intentionality to the Court of Appeals, that they're intentionally delaying. But they may be. The other thing is just that sometimes they choose to do the easier ones that come through. Like if there's, you know, if they can deal with 6 people that recently filed, and because they're just like easy snap decisions, I think they would choose that over the thing that may be a 20-page decision that either isn't going to upheave state law or go to the Supreme Court. They're just going to be more intentional with how they draft that decision. Okie doke. Oh, look at that, Gordondale Farms. So I was talking about central part of the state, another CAFO case that I'm working on. Like I said, a disproportionate number of wells in this village have been consistently testing over nitrate levels for years. We joined the case in 2019, representing 5 private community members. But before that point, they had retained a professional hydrogeologist. They had worked with the University of Stevens Point, or University of Wisconsin Stevens Point. We came in and I just had the pleasure of joining like 9 experts, it felt like, our 5 clients plus 4 folks that they had retained and worked with over time. And they presented data and graphs, and they've been doing their own private well testing, and they presented it all to DNR for a permit that was being issued in 2019. And DNR's response was, no, I don't think it's that. I don't think it's that one CAFO's fault. We'll wait and see what happens. And we challenged that, and ultimately we're able to convince the DNR that this CAFO was the likely cause of contamination of folks' wells. It doesn't stop there, because now we have to fight, as that point says, we have to fight over where monitoring occurs. You would think it'd be a simple question, right? Pick a field, monitor it. But you got to think about the crop rotation of the field, how big the field is, how frequent monitoring occurs. And all of those things are issues that the other side is going to push back on pretty vehemently as well. So now we're in the 3rd iteration of a hearing on this case in front of a judge. The case kicks off in 3 weeks, and we'll be bringing in a few hydrogeologists to explain why the field that was chosen was terrible and is going to provide some pretty bad data and is unlikely to protect the folks that are downstream and down gradient of them. And you know, I hope that by October, November, we can have some permit terms in place that say, actually, there are some other fields that you have to monitor, and the ultimate result of that may be taking fields out of rotation or changing crop rotations is more likely to just say you can't spread as much waste as you have been on these specific fields that directly feed groundwater into people's private wells. But this is another example of, you know, you fight tooth and claw for every inch. And it's a slow slog, but you know, we're nearing the end of it, and there's an opportunity to actually make some real change for those folks in the near future. All right, line 5. We are moving a bit past my area of expertise. This is a really interesting case that we have that's pending in front of an administrative law judge, where MEA is representing 350 Wisconsin, League of Women Voters of Wisconsin, and Sierra Club, and co-filed a petition to challenge a number of permits and approvals that were issued to Enbridge related to a Line 5 reroute in northern Wisconsin. 41-mile section of the pipeline around the perimeter of the Bad River Reservation. And I believe the next slide indicates all of the things that we're looking to challenge. The wetland permit. We're also looking to challenge the waterway crossing permit, arguing raising issues related to land ownership and riparian rights, the water quality certification, which for those of you who are playwright fans and know about Chekhov's gun, just remember that in the first half of this presentation, I talked about water quality standards, and that's what we're raising by that challenge, this idea that if Enbridge were allowed to move forward, they would violate water quality standards through that reroute. And then a really basic challenge related to the issuance and the use of a general permit rather than an individual permit. If we're, my case starts August 5th. The same administrative law judge is hearing this case, which runs all fall. So she has a fun fall ahead of her. Yeah, it's been an interesting opportunity to watch all of my coworkers really dig in on this case. I think it's probably, sorry, a crude oil pipeline. I'm wondering if it's because I'm touching these cables accidentally. Sorry. I can try to answer questions about Line 5, but just note that case is ongoing, and I think that we're going to have a lot of resources that will push out related to the updates on the case, opportunities to watch it, or potentially participate. But yeah, it's for those of you interested in it, I'm sure we have resources back there, and check out our website, which will tell you all the updates related to this ongoing contested case hearing. And that pulls us into some of the final updates, which are the recent decisions that we can all be hopeful about and be happy about. So the first case is related to the spills law. So this was a case that was brought by some of the same folks that brought the WDA case, which is Wisconsin Manufacturers and Commerce. And they challenged a law that had been on the books for, depending on who you ask, about 40 or 50 years, that required anyone who caused, possessed, or controlled a hazardous substance that was discharged to the environment to take actions to restore the affected air, land, and waters. And the question was, how does DNR do that, right? So in this instance, it was related to was it a laundromat, Tony? Laundromat. And whether or not DNR's recent consideration of PFAS as a hazardous substance was lawful. And ultimately, ultimately, the Supreme Court decided that DNR didn't need to go through prolonged and protracted rulemaking in order to protect the folks of Wisconsin. It takes DNR a long time to pass rules, and the arguments that the other side had offered in this case would have meant that for each individual substance that DNR would deem hazardous under the spills law, they'd have to individually pass a rule related to all of those. There were arguments that occurred, I believe, in briefing that talked about milk and beer being spilled. And I actually think they were offered by both sides, but I think it's informative as to why you can't do this through rulemaking. Because if I spill a glass of beer or of milk, that's not a hazardous substance that requires a DNR regulated cleanup. But if I, empty a pipeline of milk into a stream, that's going to require some amount of cleanup. And to say that DNR has to promulgate a rule in every strange, nuanced instance where something occurs is just unreasonable, and it's infeasible, and it would have ground this law to a complete halt. So we filed a brief to the Court of Appeals on this issue, though we didn't directly litigate it. But we certainly celebrated in our office when the decision came out in June, late June, affirming DNR's authority in that case. And I put a pretty simple ramification, which is just that the DNR has the flexibility and the authority to respond to significant contamination events. We've now seen it in the spills law case. We've seen the Supreme Court affirm it in the CAFO case. And I think that's just an important thing to bear in mind pretty regularly. It's my job to continue to push the DNR on a lot of these topics, and I don't accept the argument that they can't respond appropriately. And now the most recent decision, and maybe the most complex, Evers v. Markline, which came out 2 days ago. And that case is about DNR rulemaking and the legislature's ability to get in the way of that rulemaking. That was a case that was brought by Governor Evers, but MEA submitted 2 briefs in the case on behalf of our clients, Save Our Water and Wisconsin Conservation Voters. And the question was whether or not a very specific subcommittee within the legislature had the ability to effectively alter rule, right? Instead of it being presented to a committee on the specific topic that it was on, whether the JCRAR, Joint Committee on Review of Administrative Rules, a small 10-person committee with a conservative majority could step in and say, no, this isn't going any further, and whether or not that violated the state constitution. And victory. I've talked a lot tonight about how complex the rulemaking process is, and how there are opportunities for public comment throughout it. But I just want folks to know that this is DNR's flow chart of how it goes about passing an administrative rule. And if you start saying that around there, a very small legislative body has the ability to undermine all of the public comment that has occurred, all of the directive from the legislature from past statutes, the unbelievable amount of work that DNR had, or any administrative agency would have put into an economic analysis, identifying the underlying science to support the rule, potentially going out and having in-person meetings with affected community members, bringing in public comment. It's unconscionable. To some extent, it's unfortunate that it took the years that it did to have that decision. But very happy that there's less of a capacity to create these additional hurdles in the rulemaking process.
So, what was how many yays and nays were on that Supreme Court decision?
Yeah, it was, so the question for folks online were, how many yays or nays were on that Supreme Court decision? It was 4 in the majority opinion, which was Justices Protasewicz, Karofsky, Dalit, and Walsh Bradley, thank you. And then Justice Hagedorn concurred in part and dissented in part, and then the remaining 3 justices dissented. So we've got, is that the 3 most recent Supreme Court electees were in the majority in reaching that decision. Just something to think about. Coincidence. But yeah, it was a fantastic decision, one that I'm glad was made, and one that again opens up the ability for the Department of Natural Resources to hopefully pass more rules without legislative getting in the way. Interference, thank you. Brain wasn't working there. Which does bring up a point that maybe I haven't brought up before, but I've just kind of hinted at. As you can see, the rulemaking process, really difficult, And a lot of the weird things that the legislature has most recently put into this process has been intentional in an effort to prevent rulemaking from happening, right? DNR has a 3-year deadline to pass any rule. If it costs too much, it gets put on hold. If an independent economist that the legislature gets to identify on their own says that it costs too much, it gets put on hold. If industry creates too much pushback, it probably gets put on hold. This removes some of the interference. It doesn't fix the problem entirely. So I'm hopeful that we can see additional work to push back on some of these really, difficult laws that are in place that are intended to make this more challenging. It'd be nice to see those, go away going forward, or at least get challenged. But like I said, there's reason to be hopeful now. We've got recent Supreme Court cases that affirm DNR's authority and remove some obstacles in a way that I think we can all be really happy about and excited for the future of environmental law in the state. I have takeaways. Litigation is a tool. If I'm thinking myself as the hammer, unfortunately, that means occasionally everything looks like it can be litigated. Everything looks like a nail. That's not always the case, but I think in a lot of instances, litigation, as we've seen from some of the cases I've talked about tonight, can be really important both in creating new law and new protections for folks, and in ensuring that we don't go back. Because there are certainly groups and individuals across the state that are looking to litigate to remove some of the protections and the hard-fought wins that we've seen. Second takeaway, state laws and state agencies are really key to environmental protection in the state. That's not to say that local governments, counties, towns, villages don't have a place. I do a lot of work with county board members and folks that are trying to push their town boards and villages to enact more protections. And there is a fair amount of authority there as well. It takes planning and advocacy, weeks and months of showing up at hearings, but there are certainly opportunities to enact change and protect communities at all levels of government. I just think that when you start relying exclusively on the state, or more so the Fed, you're missing out on some key opportunities to make change closer to home. And then finally, and that this relates to the previous one, public advocacy and public pressure are critical. It's how I'm able to do what I do. I get the benefit of working with incredible advocates and what feels like experts in their fields day to day. But I can really only me can only go so far. So I rely on folks' ability to tell me, like, actually, my neighbors saw the spill, right? The eyes on the ground are not me. I'm in Madison. I can drive certain places, but if it takes me 2 hours to drive, a cleanup may have already occurred. And I can't go to every town board meeting or DNR hearing. And so it's great when MEA can come in and there's already a groundwork laid of folks that may be willing to come out on a Thursday night and hear a boring chat on environmental law. And maybe take some of the wins and take some of the information and move it forward. And speaking of moving forward, MEA can be an ally and a resource. I have cards here. I'm happy to chat after this is done. I'm happy to take questions. I'm happy to redirect you towards experts at MEA that may know more information than I do. But I would hope that everyone can think of us as someone to call if they're just trying to make sense of something. They want more resources on a specific question they have, or they're looking for help, related to challenging something that the DNR is doing. Like I said, I'm always willing to have those conversations as well. And then I'll end with a short quote from one of MEA's co-founders, who I had the opportunity to see again in person a couple days ago, which is, environmental laws don't enforce themselves, and the environment doesn't have a voice unless we speak up for it. And so I hope that MEA, in addition to all of you, can be some of those voices to really push for the change that we want to see. So I'm happy to take questions. That includes the folks online, but yeah.
Who is the Wisconsin Dairy Alliance? Who makes up the members? What is their legal structure?
That's a wonderful question, and one that, so for the folks online, someone asked me who makes up the Wisconsin Dairy Alliance as members and what is the legal structure? That is a question that has puzzled folks for generations. No. It is something that I have attempted to look into them and both them and Venture Dairy Cooperative. I've some, not to give you too much boring of my legal work, but I've submitted open records requests to like the USDA for information, and I've been told that it's proprietary information. I haven't gotten anything back. So the short answer is I don't know. The longer answer is I've tried to know, and still short answer. Yeah, they do.
I'm concerned about the artificial intelligence data centers, and I was told by the Alliance for the Great Lakes that 100 data centers are trying to use the water of the Great Lakes to cool their equipment. Their equipment which is on 24/7, gets so hot that it evaporates the water, so that the compact doesn't really work, because they're not returning hot water back to the lake. It's evaporating. And something has got to be done, I know, as a nation, down south in North Carolina, Richmond County, 800 acres, 24 data centers for Amazon, using the deep river water, which is the water for Southern Pines, and they weren't even aware of the way they were going to be affected. If all their water is evaporated, that town's going to have to move.
Yeah, so for the folks online, that was a question and some really great analysis of other data centers, particularly those in North Carolina. It's something we're looking at. We have 6 attorneys on staff. I keep looking back to our executive director who's who's giving me prompts. He'll eventually hold up a red light to be like, no, cut it off. But it's something that we've been looking into, particularly for a couple of the data centers that have recently popped up around. I'll be honest, I have not heard the 100, but that would be a staggering number of data centers.
It would be the great puzzle.
Yeah, over there.
About the remedy phase?
Yeah.
So with the groundwater monitoring around the CAFO,
Mhm.
and you said there's only about 5 of them that are actually doing the monitoring. Let's assume hypothetically that there is determination that there's excess.
Yep.
What is the remedy available to? And I mean, how does that work?
Sure. So the question was related to the remedies associated with groundwater monitoring if an exceedance would be shown. It's the really specific answer is that there's actually a regulation for it that DNR has promulgated for when there's an exceedance of nitrate and there are available regulatory responses. The most likely answer that I could think of would be either a reduction of spreading on the specific field where they've identified the cause, right? So the idea would be where they've identified would likely indicate the probable recharge zone of the wells that are showing contamination. And so they would then mandate actions that could prevent that recharge zone from leading to nitrate exceedances.
Does it allow like a reduction of the number of cattle?
I think DNR would be loath to do that. I think that their position would be, and again, I don't want to speak for DNR, but in this instance, I would presume that ultimately the result would be not a cap on the herd size, but just to say like field 42D cannot receive as much, and then it's contingent on the CAFO to ultimately identify where they would spread instead. Yep.
In speaking, sometimes I heard DNR sound like they were part of the problem, and sometimes it sounds like they're trying to without asking you to just give an opinion on DNR.
Yeah.
Where do you kind of see them at? Are they between a rock and a hard place? Or,
So for the folks online, the question was related to how maybe I or D or I won't attribute my opinions to all of MEA, we'll just say. But no. I think occasionally they put themselves between a rock and a hard place. But in other instances, you know, they see their role as an entity that should permit with the expectation that the permit achieves the goal, right? So, for example, one of the issues that I end up running into a lot when I'm talking with folks on how to comment on a permit, say, or a proposed permit, is, you know, people saying, well, I want to say that the operation's going to they're going to overspread on fields, right? And DNR's not supposed to consider like intentional malpractice or intentional unlawful actions in how they permit. It kind of undermines the point of the permit. And so in some instances, in those instances in particular, right, they're trying to walk a very tight line. And they don't always have the resources necessary to be able to identify potentially all of the environmental outcomes for what they're doing. And so they occasionally revert to the things they know and the things that they presume, as opposed to maybe investigating public comment further. I'll say one of the more frustrating things that I've had to deal with has been the fact that in some instances to find real change, particularly for CAFO permits, it seems to require members of the public to become subject matter experts in a way that I don't think is equitable. I don't think that, you know, if a CAFO has resources to pay a nutrient management planner and could put up resources to prepare an environmental impact statement, DNR has scientists on staff. The problem is that they're underfunded by the legislature pretty regularly. It feels unfair that the 5 folks that also are living next to a CAFO, have a contaminated private well, also have to learn the hydrogeology of their region just to be able to submit a comment to DNR about what they believe DNR should be doing anyway. So I think it's a number of things. I think that the underfunding is a huge issue, and as a result, occasionally in some of the programs, like I said, they revert to some of the things they know. I know, for example, DNR published an environmental impact statement related to CAFOs in the early 2000s that they occasionally still rely on, even for like hog CAFOs. And so the ability for those things to cross over, I don't think necessarily makes sense, but they just don't have the resources to prepare another. There and then over there.
Actually, I have an anecdotal response to your question that involves my son.
Okay.
Was a hydrologist. He is a hydrologist. He did work for the DNR some years ago. And his job was to issue permits to CAFOs. And I called him one day and said, how's your job going? He said, it's soul crushing. I'm like, soul crushing? What do you mean? And he explained that he was only allowed to disprove permits for CAFOs that didn't dot their I's and cross their T's. As long as they followed the letter of the law, he had to issue the permit, even though he knew in his heart it was the wrong thing to do. So in that case, you know, that individual employee would love it if MEA forced the DNR to have a different rule. So to answer your question, you know, I think some of the people that work for these very agencies really appreciate the intervention of MEA and other people who advocate for the right thing.
I will note, post 2021, we've like tried to figure out, you know, how can we, because that was when the Supreme Court finally affirmed like DNR can do these things. It's not necessarily a denial of a permit, but it alternatively is at least you can do more, and in some instances you really should do more or need to do more. And so we've tried to identify some of those folks that may, you know, want to and want to be able to do more and have the ability to do so. For example, there's a CAFO in this is probably very close to home, so I apologize if people have strong feelings on this one. I believe it's S&S Jersey Land. That was the first CAFO I can think of where DNR, I think, independently decided to require groundwater monitoring absent litigation, essentially. And so it's, it's small victories at the start, but I will just note, like, I had since had follow-ups with some folks at DNR, and I was like, what happened to that one? And some of them were like, I don't know, I wasn't involved in that decision-making process. Someone just put that in. And so, it's things like that. It's those small victories that can pile up over time and be really valuable. And I do think it starts from some people at DNR just being like, if I throw that in, who's going to notice? Over there and then down up front.
So just a follow up on Canard Farms.
Yeah.
And so, from the Supreme Court. So for a follow-up on Canard Farms and the Supreme Court decision back in 2021 that said that the DNR had the authority to install or to require monitoring wells. My understanding was that Canard Farms still hasn't installed any monitoring wells, and that they've gone the route of installing some equipment that is going to eliminate them from having any liquid manure to spread. Is that what's happening?
That is their plan. We are pretty avidly tracking that, but their intention is in the near-ish future to not have any liquid manure that will be spread on any of their fields. They put it into a black box and it comes out as clean fertilizer. I will note, it's a bit beyond my technical expertise. I do believe the technology to some extent relates back to a Gates Foundation grant about human waste management in Africa. How that's been converted to use for CAFOs is where my brain falls apart. But of note, I believe there are 3 other CAFOs that have this technology in Indiana, Texas, and Washington, and there is no data on any of them. So it's very novel. DNR wanted to give them the latitude to try that technology because they're hopeful that it sounds like a miracle technology. If it works, incredible. And DNR wanted to see how that functions. So there's while there are it hasn't been implemented yet, the groundwater monitoring, there are terms still in their permit that have the ability to immediately take effect should the technology be shown to not be feasible. And so there's like an immediate trigger, and that's why MEA and I'm tracking it as closely as I am.
Is that digester?
No, yeah, it's everything and nothing you could imagine, I think. Down up front.
Yeah, so I was hoping that you could address the emerging field of rights of nature. Hoping you can address the emerging field of rights of nature. As your quote there, said at the end, we want to speak up for the environment. We want to speak up for nature, and the challenge is nature has no legal status. And in 2010, our United States Supreme Court, in their infinite wisdom, said that money is free speech and that corporations are people. And so that's having impacts about how rules are made, and then nature stands there and doesn't have a voice. And so there's, just for anyone in the room that doesn't know, there is it's not only happening across the world, but there is actually an organization in Wisconsin called Wisconsin Rights of Nature. They're meeting on a regular basis. Anybody that wants to participate can get on their email list and participate in their Zoom calls. They've been having some some training, some meetings that, there's a number of things they've been working on. They're working with, Mari Margul at the Center for Environmental and Democratic Rights. I think they're in Seattle, out of Seattle. Margie is the one, Margie and her partner are the ones that helped the country of Ecuador write rights of nature into their constitution. There's a river in New Zealand that now has rights, legal status. Some of the tribes are working on rights of nature, legal rights for sturgeon, maybe rivers. So I'm just curious, it's obviously it's at the grassroots level right now. But the idea is to give nature legal standing in the courts, just like corporations have legal standing in the courts. And if you could talk about, rights of nature and where that's headed and how we can foster that movement. Thank you.
Yeah, I'd love to follow up more with you. I don't have probably too much. I will note that we had someone working with us do some research on that a couple of years ago. And I think that in other places, there might be a town in Florida that has passed the rights of nature, which I'm not sure how many municipalities in the United States have gone about kind of that process.
Started in Pennsylvania.
Okay.
With fracking.
Oh,
That's where it started in this country, but yeah, there's a place in Florida where they, groundwater issues, so now that groundwater has legal status.
yeah, I think, it almost assuredly would need to, as you noted, be a grassroots level to start. I don't think that this US Supreme Court is going to consider it for a while. But I truly think that I know that there have been, in the same way that we've seen local climate change efforts, the climate change committees pop up in places like Monroe County, and I think a few municipalities as well. There may be some opportunity there to get like statutory or constitutional rights of nature is just, you're looking at probably a year, I guess everything I talked about tonight is on a years long timeline. But it's definitely in its infancy, and I'd be happy to chat more about it, but I haven't had a chance to litigate it yet.
Anybody that wants to look it up, it's Wisconsin, Rights of Nature, WI, rightsofnaturewisconsin.org.
Sounds good.
Good people.
In the back.
Adam, this is probably before your time, before you were born. But going back to DNR was not always DNR. And at the time DNR came together, it was really given two functions, which is both to grant permits for economic development and other reasons, and to protect the environment. And there were thousands of hunters and fishers and trappers who came to Madison and circled around the Capitol on many a demonstration saying, you can't do this. Professor Jim McDonald from the law school, who was Arlen's associate and worked with him, had done some work that based on the scandals that the Milwaukee Journal had found, and came up with the idea of the public intervener, being that somebody has to be there to bounce off the dual responsibilities of DNRs, because by definition, they're going to conflict on many occasions.
Yep.
And so when in 1995, the public intervener was abolished, MEA came along, and as you've said, for the last 26 years, has taken the place of the public intervener. And so, I say to everybody in this room, be that hunter, that fisher, that trapper, that citizen, that recognized that you guys really were the political solution to how we got DNR in the first place. Because that's how Jim McDonald proposed to have some way to balance the protection for the environment. And that history is somewhat lost, and it shouldn't be. And that would be how I would talk about the balance of DNR and the incredible role that MEA plays in protecting that balance.
I really appreciate that. We had a conversation. We had Kathleen Falk and Arlen Christensen came into our office like 3 days ago, and Kathleen was one of the assistant attorneys general for the public intervener, and obviously Arlen was also instrumental in the intervener's office as well. So I really appreciate that. But that's it's been interesting for just a week having that history kind of said to me twice now.
Question.
Yeah.
Is on the DNR and how do they get there?
So the DNR is an agency, there's a secretary that's, what was that? Oh, so yeah, sorry for the folks online. Who is part of the DNR and how do they get there? The DNR is a large department. They have a secretary that's ahead. Her name is Kathleen. The Secretary Hyun. She came over from the National Oceanic and Atmospheric Administration, so NOAA, federal agency. But a lot of the folks at DNR are staff, right? They applied for the job. They're scientists, they're policy writers. They have some attorneys there. Certainly, there's a natural resources board. Their job is to assist in drafting and passing and approving policy. But a lot of the folks that are making like critical decisions or aggregating the data and doing the science are staff members who have scientific degrees and are just really passionate about the work that DNR does because of that history. Because, well, the hiring process within state agencies is a little wonky, as I've heard from some of my colleagues, but it's an open, like a public hiring process. And then typically, I would assume the heads of the individual departments have interviews and hire from a pool. Sometimes it's internal, but as someone that has post law school but pre-MEA applied for and been interviewed by the legal staff at the DNR, I can tell you that there's also a public process with it, and the folks that were involved were the individuals that are kind of heading the department that you're applying for. Back, I assume you have some insight into the hiring processes of DNR.
Well, I'm good the answer.
Okay.
I think from a citizen power perspective, the decision that was made to take away the role of the Natural Resources Board in selecting the secretary of the department was a critical error in public policy. And if someday the opportunity arises, everyone in this room and around the state, to try to reestablish that relationship between the Secretary of DNR and the 7 members of the Natural Resources Board, would strengthen the environmental aspect of DNR. And having put the Secretary in a political position rather than in a appointment by 7 citizens who care deeply about the environment was a terrible mistake and creates some of the conflict that you're talking about.
So hand over there.
Just sort of a comment to the question about the DNR and the sort of structure of rulemaking in the state. There's also at the county level, there are 5 representatives from every county in the state that form the Wisconsin Conservation Congress. And these are individuals that take comments from the public formally once a year, spring Fish and Game hearings. And these comments then get vetted by the Congress, get sent out the next year to be voted on by the citizens of the state. And if these statements get a favorable review by the citizens of the state, it moves on to the Natural Resources Board, where they then decide whether they're going to pass it to the DNR for study. So that's a long convoluted trail, but that is just to say that citizens do have some input through the Conservation Congress, and Conservation Congress is always looking for new people to sit on boards. I mean, conservation. Just wanted to pass that on.
Any more questions? Oh, Robert.
And I mean, what is legally possible for local, and I'm thinking here about towns or county, on the county level, to have some control over certain rulemaking?
So
I'm
the-
thinking here more about case votes for example. Yeah, yeah.
Especially Catholic.
Yeah, so the question for folks online is what is legally possible for folks at the local level to be involved in rulemaking? Are you referencing like DNR rulemaking or local ordinances?
Well, yeah, DNR rulemaking
Sure.
and can a town say come out with, or a county
Mhm.
with a stricter part of the rule that the DNR made already? I mean, or is it the DNR issues a certain rule and you cannot change that? Because I can see, I mean, even in Wisconsin, and I'll take, for example, the topography here in Doran, County
Mhm.
with the cars feature, that requires some special rules.
Mhm.
I mean, you can make a statewide rule, but that might not cover that big problem. And
So the answer in my most lawyerly voice is it depends. Which but couple, I guess here's a caveat, this isn't legal advice, second lawyer point. There are instances where local governments have the ability to at the local government, it's not level, it wouldn't be called a rule in the same way that it would be by the DNR. But if we're talking about things like Silurian dolomite standards or something like that, there is language in some of the statutes related to the ability to pass more strict standards past the state level, or past DNR's level. It does require in a lot of instances some findings, and in some instances like DNR approval. So you have to show that what you're doing is necessary, and then the DNR has to, in some respects, sign off on it. I am not aware of any groundwater quality based more strict local ordinance in kind of the vein in which you were discussing. It's not to say it doesn't exist. I haven't seen it though. And even the kind of surface water, other land use based, other more strict ordinances are pretty few and far between in the state. I think they're being addressed and thought of more like recently. A lot more folks have picked them up as something that maybe if DNR isn't going to adequately protect in their eyes, that where their home, they're considering the ability for local governments to be more involved. But that kind of is still in its infancy. Far corner.
I was wondering the entire session, what are there criteria that define what a CAFO is?
Yeah. So the question is, are there criteria that define what a CAFO is? The most basic is that it is more than 1,000 animal units. Now, an animal unit is not the same between every animal. So it's 700 dairy cows, 1,000 beef cattle, 3,000 or 2,500 swine, 20,000 chickens. There are numbers for turkeys, there's numbers for calves, but in general, the ones that we see in Wisconsin most typically are the 700 or more dairy cattle.
Is that just Wisconsin?
Those numbers hold true for, as far as I know, every state. But they're kind of based off of a relatively old EPA publication, I want to say. There are some pretty significant concerns that they don't really correlate to anything in terms of like equal mass produced of waste by all of those. But those numbers have held firm for decades now. Yeah.
I just wondered if you need, and you said it's really helpful to have public input to the politicians and stuff.
Mhm.
Look, I know one organization that uses technology, Wanna Act or whatever, and all you do is click and put your name and your email in,
Mhm.
and it goes to the representative. I mean, I think it'd be easier if we had something like that.
So-
Or we'd get a lot more responses.
I will note, at least in one instance, so a very specific law was attempting to be passed in 2019. It was a change to the livestock facility siting law in the state, and I did a mass pour out of like letters to explain everything to people, and that was basically copied and sent to their legislators. And then I showed up at the legislative hearing and the guy was like, I've seen your letters quite a bit. So I do think that what you're saying there has worked in the past before, at least to get, people out and involved.
I think a lot of us want to do it, but we don't know, like that man said, where do you go for the DNR and so on.
Mhm. Any other questions? Otherwise, we're getting people starting to wrap out or head out.
Thank you everyone for coming on tonight. Let's give Adam another round of applause.